Be ready. 5 seconds. The two writ petitions arise out of similar set of facts and seek to raise challenge to notices bearing date 18/6/2022 directing the petitioners to show cause in respect of the proposed action of blacklisting/debarment. Accordingly, with the consent of the parties, the two petitions have been heard and are being disposed of by means of a common order. Pleadings have been exchanged between the parties in both the petitions. At the very outset, it would be relevant to take notice of the fact that the writ petition in Writ C number 18053 of 2022, Messrs. B. Sits Private Limited versus Purvanchand Vidyut Vitaran Nigam Limited and another had approached this court earlier seeking to challenge notice dated 18/5/2022 whereby the petitioner had been directed to show cause in respect of a proposed action of blacklisting/debarment. The writ court allowed the writ petition by means of a judgment dated 26/5/2022 taking into consideration the fact that in the aforestated notice the authority concerned had already recorded its conclusion with regard to explanation furnished by the petitioner earlier and had found the same to be unsatisfactory. The court held that since the respondent authority had already expressed its mind, the exercise which was to follow would be an empty formality. Accordingly, the notice was quashed, leaving it open to the respondent corporation to issue a fresh notice in accordance with law if so advised. It is pursuant to the judgments in the earlier round of litigation referred to above that the respondent number 2 issued notices dated 18/6/2022 against the petitioners in the two writ petitions, in terms of which they were directed to show cause as to why, in the light of the facts stated in the notices, the petitioner firms be not blacklisted/debarred for a period of 2 years. Learned senior counsel appearing for the petitioners while assailing the show cause notices dated 18/6/2022 issued by the respondent number 2 submits as under. The notices dated 18/6/2022, though stated to be for the purpose of giving the petitioners a show cause, is in fact in the nature of an order which has been issued with premeditation, with malice writ large in issuing the said notices. The notices are founded on incorrect and incomplete facts which have been selectively stated to prejudice the petitioners. The entire exercise sought to be undertaken is arbitrary and opposed to the mandate of Article 14 of the Constitution. An attempt has also been made to draw attention of the court to the merits of the case and the defense which is sought to be put up by the petitioner firms in response to the imputations made in the show cause notices. The respondents have filed counter affidavits in both the petitions in which it has been categorically averred that the notices dated 18/6/2022 simply call upon the petitioner firms to submit an explanation for violation of the various conditions under the agreement. It is submitted that the notices have been issued strictly in accordance with the liberty granted by this court.